Good morning, ladies and gentlemen. Today I'm presenting this submission along with my colleague Tian Ma. We really appreciate the opportunity given to us to present this submission to Personal Injury Compensation Parliamentary Committee relating to doctors' negligence in personal injury cases involving medical malpractices. Before we begin, let us first introduce our group to you. We are Medico Legal Rights Care Society, in short, MLRCS. We are a Master of Law students at Griffith University's Gold Coast campus in Queensland. Our belief is that quality medical care is a birthright of every individual. We are solicitous to advocate the rights of patients grieved due to medical negligence by doctors. At MLRCS, we are proponent of patients' right for an adequate and fast remedial system to compensate for their injuries. Our objective is to seek for reform in Queensland's legislation and common law that lays complete onus on plaintiff to prove breach of duty and causation of injury experienced due to negligence of a doctor. In most cases, causing permanent injuries and disabilities to patient for rest of their life. We have three main goals with this submission. First, to bring reform in Queensland legislation and common law to reduce burden of proof and the requirement to prove breach and causation by plaintiff. Second, reducing complexity and cost of legal proceedings and causation hurdles due to lack of evidence. Third, we would like to suggest few victim compensation options and also highlight the effect of compensation on taxpayers.
Thank you, Bovicia. Hello everyone, I'm Tian. Next, I will analyze the current situation of medical negligence in Australia through the data. Medical negligence can be caused by medical professional for doctor or nurse. In this situation, the Medical Legal Rights Care Society will focus on the limitation laid out in the existing law. Provide negligent doctor an easy escape route. Our objective is to stop this injuries by seeking reduction or removal of burden of proof from the shoulder for a patient, who by law and statutes are required to provide breach and cohesion for injury experienced due to medical negligence for a doctor, by focus further making doctor liable for the damage caused due to their negligence. As per a recent study, rates of adverse medical evidence have increased in Australia compared to other developed nations, whereas the number of new claims have decreased with time. The rise a concern relevant to the complex created by law that is acting as over deterrent for victims to file claim. The disproportion can easily be understood by comparing the statistic on adverse evidence with number of claims rejected. Firstly, let's move on left hand. In 2013, Australian Commission of Safe and Quality in Healthcare conducted a research to assess the impact of hospital financial loss resulting from adverse events. They found 12% to 16.5% of hospital spending were due to adverse events. In 2017 to 2018, costs associated with hospital court completion were about 4.1 billion or 8.9% of hospital total spending. Okay, let's move on the right hand. This report covered 28 hospitals and includes the medical records of 14,179 patients, with relevant to 16.6% of cases were caused by adverse evidence, and more than 50% of these cases could be prevented. All of these cases can be classified as short-term and long-term injury or disability resulting from medical negligence. In addition, according to the report, 46 8.6 of adverse events cause minimal disability, and 13.7 cause permanent disability in patients by the adverse event. This bar chart is the number of hospital-acquired complications in the year of 2014 to 2018. From this bar chart, we can see that the number of the hospital-acquired complications is increasing with the year. Healthcare-associated infections, delirium, respiratory, and cardiac being most common cases, rising due to doctor negligence. As per the statistics relevant by the Medical Indemnity and National Collection, medical malpractice claim results by court adjudication for 2006 to 2011 were almost 3.8% of all 1,496 claims. Fund used to facilitate paying of medical malpractice claims were about 48.6 million per year for taxpayer money. As per New South Wales government's public available data, more than 20 million were paid in medical negligence claims in December 2017. The Health Directorate also paid out almost 30 million in July 2017 and over 9 million in January 2018 from Treasury Managed Fund. It is estimated the Hunter New English Health has disputed over 69 million of taxpayer money for medical negligence claims. The Health Directorate closed 105 medical negligence claims between October 2016 to 2018. Next, my group member will introduce the next part.
In Australia, as a matter of case precedent, the duty of care is always owned by a medical practitioner. However, the plaintiff is required to establish a connection between the breach of duty and causation of injury suffered. If he fails to draw the connection between the two, then the claim for injury cannot be sustained. Unfortunately, in medical negligence cases, this connection is not always clear. The plaintiff needs to prove that failure to exercise reasonable care has caused the damage suffered by him. Most claims fail at the causation hurdle, and plaintiff is deprived of justice. In Queensland, breach of duty and causation are covered under common law as well as the statute. The cases pertaining to medical negligence by doctors are referred in correlation with Section 9, 21 and 22 of Civil Liability Act 2003, Queensland. Looking at the sections, Section 9 describes forcibility of harm and precautions to be taken by reasonable person, which is doctor in this context. Section 21 explains the duty of doctor to warn the patient of risks. The standard of care for professional is explained in Section 22, which subtly also provides a protection for doctors to prove they acted in a way that is widely accepted by peers and professionals in their community. The hardest issue faced by plaintiff is of proving causation of injury in medical liability cases, which are covered under Section 11, 1, 2, and 3. It defines the two elements required to establish breach of duty, causing harm, that is, factual causation, and scope of liability. This section acts as a hurdle for the plaintiff to prove that if no breach occurred, things could have turned out differently. The damage can be claimed under various sections, but key sections for medical negligence are Section 50 and 51, 54 and 61. The Section 50 and 51 elaborates on personal injury damages and define the type of injuries. Section 54 explains assessment of damage, for loss of earnings, present, past, or future. And Section 62 provides scale for calculation to assess the compensation for damages based on injury scale value for courts. In common law, like the statute, the onus to prove breach and causation is on plaintiff, as seen in Morocco versus Marshman case. The judge in this case stated that even if plaintiff was able to prove breach of duty, surpassing the issue of causation will still be difficult. Hence, most cases fail to even reach court, as proving negligence on both the grounds is tough, considering the technicalities involved in this complex field of work. The two other pieces of hurdles faced by plaintiff are that law requires causation of harm to be over 50%, as stated in Tabet versus Get. Another being an issue linked to unity of doctors that are practicing in the same state, who often show unwillingness to give evidence against their peers in the same medical profession. This adds up to the expense for a plaintiff to get a report from an interstate doctor or maybe from experts in UK. The cost of these reports vary from anything between 3,000 Australian dollars to 5,000 Australian dollars. The breach of duty in common law can still be proved looking at the judgment of Mason J. in Wongshire Council v. Shirt case. A plaintiff is required to prove if defendant conduct fails below required standard and risk of harm are foreseeable to the defendant. But under the statute's section 21 of CLA, it becomes difficult to prove if the plaintiff was warned adequately of the risk to make reasonable informed decision.
In general, medical professionals, established doctors are well respected in Australia. They are considered to hold a high stature in society, who often work tirelessly to deliver best possible care to their patients. In research conducted in 2016 by Roy Morgan, doctors were found to be amongst the top 3 most trusted professions in Australia. At the Medical Legal Right Care Society, we respect doctors. They unparalleled dedicate their reflective in their work, and we would not wish to undermine their hard work. We understand that in circle of life, everything can't go as planned, and mistake can happen, lead to injuries, irreversible dangers, and even death in some cases. Our fight is against the system that failed to deliver the just remedy to a patient who is already in pain and suffering. In medical negligence case, the complexity of preventing harm and the finding admissible evidence itself acts as high barrier for the victim to make a claim for injury caused to him by someone else's negligence, which is the cause of getting medical legal opinion and various other legal fee acts as other determinant. Therefore, the Medical Legal Rights Care Society is fighting for changing the current medical negligence redressing system in Queensland, established in cases involving medical spending. We call for reform in the current compensation system from the very point of simplifying the claim process and recommending a no-fault-liability scheme, which only requires claim to show that the medical error was causative facts leading injury or disablement. The current compensation system allows damage to be claimed under Civil Liability Act 2005. The maximum amount claimable is restricted up to $3 398,700. We contact the putting a cap on the claimable amounts, curtail the opportunity that a victim deserves who is suffering from permanent disability or loss of earning due to the enduring costs, without ignoring the legacy and the expecting legal battle they have to fight with multi-million-dollar institutions. Human beings are far from being perfect, so medical accidents are bound to happen. It is a social phenomenon, and the adversarial and fault-finding attitude in current system is not favorable for opponents to prevail in classical governance. The Medical Legal Right Care Society property to bypass the process set out in the common law relevant to the burden of proof landed on the victim's shoulder, which acts as an over-detected fact. Our organization recommends a no-fault compensation scheme in line with one followed in New Zealand, Scandinavia, Denmark, and Finland. In these countries, heavy emphasis is landing on disciplining the daughter at fault. This scheme will allow the victim to overcome the cohesion handle by requiring them to be liable to only provide the cohesion rather than providing the fault, unlike the existing system. This will significantly help in reducing the expensive, burdensome, and expected delay of legal process, which the government will save in the legal and administrative costs. The benefit is that claim can be examined properly without the typical adversary process. We propose formation for Square No-Fault National Injury Insurance Scheme for claimants who experience any kind of injury, temporary permanent due to the medical negligence. As per study conducted in relation to New Zealand No-Fault Scheme, the administrative cost is expected to be less than 10% of the income. Looking at the larger picture, no-fault scheme provides a potential advantage by changing the mindsets of doctors by providing them an opportunity to learn from their own mistakes and prevent errors. Furthermore, it will encourage complex reporting of adverse evidence and overcome those, providing better and across dates for the government to make a more informed police decision. With a non-adversarial approach, investigation can be conducted more properly by involving a panel of experts rather than investing time and money of course to hear from poorly qualified or basic experts witness. A litigation process is equally stressful for doctors and their family as much as it is for the patients and their family. The no-litigious approach will improve the benefit to all stakeholders, include the suffering patient, as they enable them to restore life and contribute to society rather than depend on the government's grant. In conclusion, we suggest that it should be introduced as a pilot for limited time and closely monitor the outcome before implementing it nationwide. That's all for our presentation. Thank you for your listening. Thank you for your watching.